Welcome back. This is a video in the Complete Guide video series, but like much of what we talk about in the Complete Guide unit, it applies not only to memo writing, but to all sorts of legal writing. It has to do with something I call nicknaming. You can use nicknames in memos, briefs, correspondence, and other legal documents. In fact, the general rule for legal writing, any kind of legal writing, is that we nickname players on first mention wherever that occurs. So if you're writing a memo, you'll often be nicknaming the parties very early on in the question section. That said, you might nickname some of the players in the answer and some in the facts. There's no specific place where all the nicknaming occurs. It just occurs as the various players come into your narrative. If the first place you mention someone is in the garnerized question, then you should nickname her there. If the first place you mention someone is in the facts section, then you should nickname him there. Of course, you only need to nickname a player if he, she, or it has a long name that you're going to be using frequently throughout the paper. If you want to nickname a person or entity, then, on the first mention of that person or entity, you need to do three things. Identify the subject's role, present the subject's full, proper name, and give the subject a parenthetical nickname that you'll be using forever afterward in the paper. Note that when I'm grading, I'll write the abbreviation FN+P to mean full name plus parenthetical to remind you if you've forgotten to go through our nicknaming protocol. Let's see some examples. As you can see, I've got three nicknames here. The first nickname is for an entity, in particular a law firm. Note that I've used the firm's full name, including the PC at the end, and then I've abbreviated the name BLF. That's what I mean when I say to give the full, proper name before the nickname. The second nickname, which is for a person, not an entity, is again preceded by a full, proper name. And just to be completely clear, when I say we need to use the full proper name, I mean the legal name. So I'd use Charlotte even if the client went by Charlie. Of course, if Charlie was her legal name, then I'd use that. For instance, I had a client once named Frankie, and I did use Frankie on all the documents because that was indeed his given name. The third nickname is for another entity. I've again communicated the entity's official name before its nickname, including all of the corporate alphabet soup at the end. Note too that for the second and third nicknames, the nickname for the parties to the case, I've identified the parties' roles as plaintiff or defendant. Let's take a look now at a slight variation on this same example. You can nickname the parties to the case plaintiff and defendant instead of shortening their proper names, but don't flip-flop. In other words, in this example, you wouldn't later call Charlotte Ms. Rossi. You'd have to stick with defendant. Once you nickname someone or something, you're stuck with the nickname. As a final note on this example, and one especially pertinent to human clients as opposed to entities, I tend to prefer using a nickname with Mr. or Ms. and the client's surname because I want to humanize my client, and nicknames like plaintiff and defendant are just too dry and impersonal. This means I have to use this same sort of nickname for the opponent because it would be too heavy-handed and obvious if I used a dehumanizing nickname for the opponent and a personalizing nickname for my client. For another slight variation on this same example, take a look at this. This time, for Charlotte's nickname, I've used both her surname and defendant. The point here is that if you must flip-flop, you just can't stick to a single nickname, then give yourself license to do so. This can happen when there are more than one authors on the paper. Let's switch gears a bit now. All the examples of nicknames we've seen so far are for people and entities, but we can also use nicknames for events. A nickname makes sense here because it spares us from having to type arrested, searched, and interrogated every time we're talking about this transaction, and it spares our readers from having to read it over and over. Our final example is similar to the last. It uses a nickname for a series of events. This is a mouthful: primary petit mal epileptic seizure and secondary myoclonic seizure. It's actually difficult to say, and it's also difficult to type. So spare yourself the pain of having to type it over and over again, and spare your reader the pain of having to say it over and over again in her head and use the nickname instead. With that, let's see some guidelines for nicknaming. First, use nicknames to save room. As I said before, you're only going to nickname players who have long names that you'll be using frequently. A client with a one-word name, for instance, like Cher, wouldn't need a nickname. Neither would a witness you mention once but never discuss again. Second, capitalize your nicknames. Once you've proffered a nickname, that nickname becomes a proper noun, like Colorado, and it needs to be capitalized whenever you use it anywhere in the rest of the document. This puts the reader on notice, for example, when he sees the word company with a capital C, that you're talking about Charles Schwab, the plaintiff in the case, and not some other company. Finally, you might be wondering about the quotation marks. Well, they're optional. I like to use both parentheses and quotation marks, and this is what I see most attorneys doing. However, I can appreciate the argument that the quotations aren't necessary as they're duplicating what the parentheses are already doing. So if you want to omit the quotation marks, that's fine with me. With that, you have the necessary information to start nicknaming your players. Thanks, and see you again.